Thank you, President, and congratulations again on such a magnificent legal profession dinner last Friday night. I had the very great pleasure of being one of the guests at the dinner. And apart from it being a wonderfully collegiate occasion, it was magnificent to see such a diverse range of award winners acknowledged for their wonderful service to the profession and the community. Advocacy in the applications jurisdiction is the topic of the paper that I have in front of me, which I think roughly aligns with the topic that was advertised, which is a good thing. Some of you have heard me say before that there is a prime and fundamental rule of good advocacy. It is the 5 Ps. Proper preparation prevents poor performance. There is simply no replacement for proper preparation. And that is especially so in the Supreme Court applications jurisdiction, a place described by the retired Senior Judge Administrator, Justice Byrne, as a jurisdiction for the quick or the dead. I have been known to describe it, particularly on a busy applications day, as a place where angels fear to tread. Now, much of what I have to say today may seem basic, but can I tell you, with nearly 11 years of experience sitting in applications as a judge, I can assure you that nearly every day we see examples of advocates letting their clients down because they are unprepared, or even more fundamentally, because they are out of their depth and simply don't know what they're doing. Proper preparation doesn't just mean having a comprehensive knowledge of your case. That's an absolute given. It means knowing and understanding the jurisdiction in which you are appearing, knowing and understanding the forensic and procedural technicalities attaching to the case in which you are appearing, and even knowing and understanding the judge before whom you are appearing. On a contested application, your job is to seek to persuade the judge to accept and act on your submissions. And you have to do that calmly and helpfully in what can often be a pressure cooker environment. On a reasonably full Supreme Court applications day, the judge before whom you are appearing may well have dealt with a few bail applications, some directions relating to a dangerous prisoner matter, and 1 or 2 criminal confiscation matters before they even reach the conventional civil applications. And in that space, as you know, the judge will be dealing with the full gamut of civil law, commercial contracts, torts and sanctions of settlements, building matters, equitable relief, succession claims, injunctions, pleadings, disputes, disclosure arguments, administrative law, judicial review, etc., etc., etc. And that's even before we get to the so-called straightforward procedural applications and the wide range of possibilities that lurk in that space. Trust me, it's a lot to get across in one day if you're a judge. And that's why a judge will breathe an enormous sigh of relief when they have appearing before them a competent, prepared advocate who can assist the judge by guiding them to the correct solution. So, what does being properly prepared look like? The first thing you need to do is know your jurisdiction. Once upon a time, when we had the rules of the Supreme Court, there were all sorts of arcane rules about what matters needed to be brought on motion and which ones on summons, whether they were heard in chambers or notionally in court, and even as to whether one stood or sat while one was making submissions. It was even more difficult for counsel because there are different rules as to the matters for which you robed and didn't robe. Those Byzantine rules went out with the advent of the Uniform Civil Procedure Rules and a single applications procedure. But even so, it's not enough for you simply to look at Chapter 2, Parts 4 and 5 of the Uniform Civil Procedure Rules and think you know it all, although that's a pretty good place to start. You can breathe a sigh of relief. I'm not going to stand here this evening and simply read through passages of the Uniform Civil Procedure Rules and walk you through relevant passages of the Uniform Civil Procedure Rules. Your grown-ups, if you're going to be practising in the Supreme Court or the District Court or the Magistrates Court for that matter, you need to know the Uniform Civil Procedure Rules. You need to know your rules. There's no simpler thing that I can say. You've got to know your rules. Those of us of a certain age grew up practising in the Chamber's jurisdiction before Master Lee, as he then was. That's why people of my generation know procedural rules backward, because none of us dared appear in the Master's chambers as they then were, unless you knew the rules backwards. It was as simple as that. So I'm not going to go through the rules with you. What I am going to spend a bit of time talking about is the other body of documentation with which you need to be acquainted, and about which there is, I regret to say, a large degree of, let's be polite, non-knowledge, and that is the practice directions. Okay? There is simply no excuse for advocates before the Supreme Court not being familiar with the practice directions that relate to the applications that they are concerned with. In preparing this presentation, I went through and did a long list of the practice directions that I could talk to you about. I think I ended up with about 30 of them. I may yet end up talking about all 30. I'll see how time goes. I won't. I've cut it down to the essentials, but even the essentials, the practice directions that you really need to know about, run for a little while. Let's start with the most fundamental of all, practice direction number 6 of 2004, which was most recently updated on the 11th of August 2016. That's the practice direction that requires practitioners to provide written outlines of argument in all contested and ex parte hearings before a judge or registrar, including where practicable bail applications in the application's jurisdictions. You've got to have a written outline. Every day, literally every day in applications, we have practitioners turn up without written outlines. The practice direction goes on to say what the outline should look like. So it's not as if the court hasn't tried to be helpful. An outline should, A, provide a concise summary of the argument in point form, B, identify relevant authorities and legislative provisions, C, I want you to listen carefully to this, usually not exceed 4 pages. It's in the practice direction. I cannot tell you how annoying it is when you have a thesis handed up to you, masquerading as an outline of submissions. And D, attach a chronology where appropriate. I'll come back and talk about chronologies in a minute. That practice direction, let me say it again, 6 of 2004, also refers to the material to be read and the necessity to complete an appearance slip. Can I tell you, there's nothing new about requiring outlines of submissions in applications. The requirement for an outline of argument was first promulgated in Practice Direction 12 of 1995. So it's not as if this is something that's been lurking and hiding away. Then there's Practice Direction 3 of 2008, and again, you should be aware of this. It relevantly does 2 things. It says that written submissions are to be taken as filed and read. Now, what's the significance of that? The significance of that is the Supreme Court is a court of record. The record is everything. What's on the file is evidence and comprehensive evidence of the proceeding before the court. When your submissions are taken to be filed and read, they become part of the record. What the practice direction also says is this, and I quote, where such submissions are presented, 2 copies should be provided, 1 for the file and 1 working copy for the judge. Again, every day in applications we have practitioners turn up. They might have known that they need to have an outline of submissions, and then I say, where's the working copy? And they look at me with a blank look on their face, and then there's a lot of scurrying around at the bar table as they either borrow back the copy that they'd given their opponent or steal the one from the clerk sitting next to them. Practice Direction 3 of 2008. Practice Direction 7 of 2014. Now, that is the practice direction that was promulgated after Ausscript became the transcription service provider in the courts. And it sets out, for the purposes of transcription, the requirements for identifying the proceedings, those appearing in the proceedings, and the witnesses. Relevantly, it says this in paragraph 7, except at call-overs and reviews, a party appearing in a proceeding, whether a legal representative or a person appearing without legal representation, will at the outset state, now listen to this carefully, we tell you how to announce your appearance. Okay? This is what I'm about to read to you. This is what you state. Your surname and initials, spelling your surname. The professional capacity, if any, in which you appear, and the party or parties that you represent. That's all you do. I'll come back and talk about that again a little later. And the other thing that you need to say if you're a solicitor is the firm with which you are connected. So that's Practice Direction 7 of 2014. Practice Direction 16 of 2013, citation of authority. With the advent of legal search engines that will allow you to spew innumerable cases, most of them unreported, most of them arcane, out on a piece of paper, what we have found in sort of logarithmically increasing quantities are outlines of submissions burdened by repetitious and unnecessary citations for propositions. That's why Practice Direction 16 of 2013 says that the purpose of that practice direction is to ensure that the court is provided with the most authoritative and functional versions of the relevant authorities, and to encourage parties to limit their citation of authority to those judgments which are apt to assist the court materially in resolving the real matters in dispute. Here's a tip. Austly is a really good thing and it's really handy, but it's not an authorised reporting body. The Commonwealth Law Reports are, the Queensland Reports are. Okay? You don't earn any brownie points with a judge handing up an Austly printout when the judge well knows that the case that you're referring to is reported in the Commonwealth Law Reports. So citation of authorised reports is preferred, and importantly, as the practice direction makes clear, you need to limit your citation to authorities and only to the authorities necessary to establish the relevant principles or propositions. You should not cite authorities which merely rephrase, illustrate or apply. Then we have Practice Direction 4 of 2010, which was most recently reissued, I think on the 19th of October last year. I think I've got a typo in my notes here. That deals with consent orders which can be made by the registrar. It sets out extensive lists of two things. One, the sorts of consent orders which should ordinarily initially be sought to be made by the registrar, and two, the sorts of orders which are not apt for making by the registrar. It contains a handy list of the documents that you need to provide to the registrar in order to obtain your consent order. And those of you with sharp eyes might go looking towards the end of the practice direction because it in fact provides for adverse cost consequences. If a party goes before a judge and neither consents to nor opposes an order which could have been made by way of a registrar's consent order. Now, time's against us. I'm not going to keep going with the list. Those of you who are keeping careful notes or committing this to your photographic memories can simply make a note of the following, which you should immediately have to hand in mind. Practice Direction 1 of 2007, freezing orders, what we used to call Morava orders. Practice Direction 2 of 2007, search orders, what we used to call Anton Pillar orders. They're really important, those practice directions, if you're seeking urgent relief from the court. Practice Direction 3 of 2007, agreed or fixed costs. It expressly encourages parties to fix amounts of costs and it facilitates the court's discretion to fix costs. Practice Direction 1 of 2008, not directly applicable to applications, but it talks about taking evidence by telephone and video link. So if you're ever in a situation where you need to take evidence in an application by telephone or video link, it's worth your while having a look at that. Practice Direction 11 of 2012 deals with the supervised case list. Practice Direction 17 of 2012 deals with case flow management. Practice Direction 10 of 2014 deals with the supervised case list and self-represented litigants. Practice Direction 2 of 2017 deals with class actions. I could go on, but I won't. Why do you need to know this? There is a simple answer, and the simple answer was given by Dyson Hayden in a speech he gave in Darwin in 2006, when he quoted Sir Owen Dixon's aphorism that advocacy is tact in action, and then went on to observe, quote, "The essence of tact is to avoid irritating a judge." Now, the best way to avoid irritating a judge is to know your jurisdiction and, above all, be prepared. So the next heading in my notes says prepare, prepare, prepare. Consider why you are bringing the application. Your client may not be able to afford a series of interlocutory victories or tolerate the delay associated with appeals from your interlocutory victories if that's all at the expense of the battle that they really want to win at the end of the day. On the other side of the coin, consider why you are resisting the application. Is this really the fight that your client wants to have? If you're opposing an application, perhaps turn your minds to how can you turn the application to your advantage? For example, by achieving a result of directions which will advance the matter to resolution. In your preparation, it is of absolute importance to get your facts straight. And an important part of that process is the preparation of a chronology, preferably a chronology that you can then hand to the judge as part of your submissions. It needs to be a complete chronology, not just one that suits your side. In your preparation for the hearing, get the exhibited correspondence in order. I cannot tell you how frustrating it is for a judge when they're sorting through the material to be told that one letter is in this affidavit, but the response is in that affidavit and the reply is in a third affidavit, but then you need to go back to the first affidavit to see what followed from that. You end up on the bench with papers everywhere. Why people find it impossible simply to prepare an affidavit that has a complete exhibit of the relevant correspondence in chronological order is simply beyond me. Then you need to start thinking about your outline, the shape of your outline. It will contain, as I've said or have attached to it, an accurate chronology. It will have a concise statement of the relevant facts, footnoted or referenced to the evidence. Not the facts as you'd like them to be, the facts that the evidence proves. It will contain a concise statement of the relevant law. And I've already made the point that's in the practice direction that you don't need to cite every conceivable authority for a proposition. You need to cite the relevant legislation. You must always know what rule or statutory provision or decided case regulates the claims you are making. Again, in the old days, before we had rules relating to third-party disclosure, an application to seek an order for third-party discovery, as it was then known, was governed by one case and one case only. It was a case called Rossi and Ballymore Towers. It was a decision, again, of Master Lee, as he then was. If you went up on an application for third-party discovery without knowing Rossi and Ballymore Towers backwards, you were just buying yourself a very, very bad and embarrassing day. Don't, in your outline, be diffuse. Anticipate and concentrate your arguments and your efforts on the real matters in issue. So, for example, in applications for interlocutory injunctions, 9 times out of 10, the decisive consideration is on the balance of convenience. 9 times out of 10, there's really no issue that there's a prima facie case or at least a serious question to be tried. So there's no point in spending hours working up a case about whether there's a prima facie case or a serious question. If, as the applicant, you fail to prove that the balance of convenience favours the grant of relief, then you've lost. Simple as that. Now, as an applicant, you know you're going to be met by contentions such as damages are an adequate remedy, or your undertaking as to damages isn't worth the paper it's written on. So anticipate those submissions and have your arguments ready for them. Make it easy for the judge to decide for you. If you are for an applicant, that means you shouldn't have a barrage of alternative propositions and say to the judge, we can win on all of these. The more points you have, the more confused the judge is going to get, and the less likely it is that you've got substance in any of them. As Walter Sofronoff used to say when lecturing about advocacy, in any case there's 1, maximum 2 hooks, as Sofronoff used to call them. Okay? If you're for an applicant, what's your best point? What's the killer point that wins the case for you or wins the application for you? It is, of course, different for those resisting an application. They will often want to raise a number of hurdles over which the applicant must rise before the relief can be obtained. Appreciate, as I'm sure you will, that the judge will almost certainly not have read the material. That's simply because we don't have the time. It would be nice, but in reality, it just doesn't work that way. One of the reasons we don't, of course, is because, as we all know, a significant number of matters settle on the day. So there's not a lot of point in reading a whole lot of material for a matter that's going to settle. The fact that the judge may not have read the material emphasises the importance of a persuasive outline of argument. The outline should enable the case to be won at the time, or if the decision is reserved, and don't underestimate this, if the decision is reserved and the judge takes the material away, the first thing the judge is going to be looking at is your outline. So it could end up being a persuasive block which the judge on mature reflection uses for basing the reserved decision. The day of the hearing. Now, this is going to sound basic. I'm going to rattle through them, but please understand, I'm not insulting anybody here, I'm just giving you the benefit of experience. Check the law list. Which court are you in? Which court is the call over going to be conducted in? Just because it was there yesterday doesn't mean it's going to be there tomorrow. They do change at courts occasionally for different reasons, practical reasons. Not all of the courts are equipped for video link, for example. So sometimes we have to change the courts around. Be early for the call over. There's nothing worse than being out of breath. Yes, there is. It's being late. Give the judge an accurate time estimate. And on this point, if you know, as you know, when applications are filed, there are time estimates given on the application. If you know before the day, either because you're for the applicant or the respondent, that the time estimate that's been allocated is inadequate, let the registry know and let the judge know. I can assure you there's few things more frustrating than doing a call over where on the list in front of me, a matter's got a 15-minute time estimate and you're told by the people appearing that the matter's going to take 2 hours. Okay, it just completely blows the list apart for the day. So let the registry, or if it's at the last minute, let the judge's associate know. Of course, if you're communicating with the judge's associate, you can't do that ex parte. You have to keep the other side in the loop with any of those communications. If you know the matter's going to be longer than 2 hours, talk to your opponent about directions for the matter to be sent off to the civil list. We just don't have the time and resources available to us to deal with matters longer than 2 hours in applications. And your matter will be sent off to the civil list. Talk to your opponent about the appropriate directions for that. Consent orders during the call over. Ask yourself, is it a matter which can be dealt with by consent, or does it require an exercise of judicial discretion? Ask yourself, are all of the affected parties represented? If you can't put your hand on your heart and answer yes to both of those questions, call it a short matter. Save embarrassing yourself when the judge says, for whatever reason, this can't properly be dealt with as a consent order. After the call over, listen to the allocation of matters. Don't wander off. I know there are several coffee opportunities available in the George Street precinct. It is just as likely as not that the list will collapse and your matter will be called on early. Unless you're given a not before time, stay around. That being said, you will of course be, because the judge will allocate the matters, you will be given some time outside. How are you going to use it? Are you going to go and have a cup of coffee, or are you going to talk to your opponent and try and settle the matter? Remember, it's your responsibility to solve your client's problems. As to the hearing itself, I've already talked about appearance slips. Make sure the slip is accurate. Here's one of my personal gripes. Why people can't talk to one another and put their names on one appearance slip is simply beyond me. In almost every matter, the judge has handed 2 or 3 appearance slips on which each party has written their own individual name. Why you can't sort of go over to your opponent and say, hey, do you want to fill this out? As I say, it's just, I grieve for the rainforests of the Amazon. Announcing your appearance, I've already referred to the practice direction. Don't say good morning to the judge. It's not a social occasion. You're not there for a social occasion. Saying good morning, in fact, tends to suggest an unwarranted degree of familiarity with the judge. Don't say, quote, for the record, unquote. Apart from being an appalling Americanism, the use of that phrase can make you seem presumptuous. The Supreme Court is a court of record. The proceedings are being recorded. Okay? Don't say, my name is Mr., Mrs. or Ms., whatever. It is highly unlikely that Mr., Mrs. or Ms. is the name recorded on your birth certificate. What you do, as I said, is you follow the practice direction. May it please the court, my name is Smith, initials AB. I'm a solicitor in the employ of Jones, and I appear in this matter for the applicant. That's what the practice direction tells you to do. Then you get to reading your material. Be organised with your bundles immediately to hand. I can promise you nothing appears more disorganised than an advocate who, having announced their appearance, immediately starts throwing paper around the bar table, trying to work out what needs to be handed up. Do you need leave to file and read material? If so, you should be looking at Rule 437. Can you use copies of late deposed to affidavits with an undertaking to file the original? Yes, you can, Rule 965. Do you need to tender an exhibit? If so, know how to tender documents. Do you have your working copies for the judge? Do you need an affidavit of service? Does it comply with Rule 120? There may be a temptation for you to take objections to the other side's material. All I can say about that is you should exercise discretion in taking those objections. Mostly, I have to tell you, they are a waste of time. They are either related to technical matters which can be waived, or else, where they relate to matters of substance, you may end up simply provoking a successful application for an adjournment where, when you come back on the next occasion, the other side is going to be even better prepared. In short, just because a sentence in an affidavit is objectionable doesn't mean you are obliged to object to it. Use judgment and discretion in the matter. Much the same applies to cross-examining in applications. You can do it, but why do you want to do it? What are you trying to achieve? As a rule of thumb, you should only cross-examine if you've got a really, really good reason to. In applications, you will almost certainly be limited in your scope of cross-examination. It will really only be useful if the point is of short compass and relates, for example, to potentially important and clearly relevant information within the other party's knowledge, which the cross-examining party could not otherwise reasonably ascertain. Or it may be a case in which, for the purposes of satisfying the rule in Brown and Dunn, You have to cross-examine and effectively put your case in order to be able to sustain a contention that the deponent ought not be accepted on oath. That, ladies and gentlemen, is perilous territory, and it's the sort of thing you would think long and hard about. Know the requirements, if you're going to go down this path, of Rule 439, which are the notice requirements for deponents for cross-examination. When you get to oral argument, don't just read out your submissions. Pay attention to the judge, engage with the judge, interact with the judge. The judge wants an efficient, accurate resolution of the dispute. And the reality is in these days, many judges will be interested in formulating directions to bring a matter to a trial. Interlocutory skirmishes frequently bring delay, expense and inconvenience which are out of all proportion to the results which the contest may yield. In your oral submissions, concentrate on the essentials of your case and the essentials of the case put against you. You may be asked for authority for a proposition that you advance. Never, ever say that you rely on the court's inherent jurisdiction or it's the practice of the court. Both of those are one step short of simply standing there, throwing your hands in the air and saying it's the vibe. Of course, if you followed the prime rule, proper preparation prevents poor performance, you won't be stuck for any of these authorities. You'll have them immediately to hand. Always have a draft order. In fact, have various versions of the draft order to cover the various permutations of possible outcome. If you are for an applicant, don't just ask for judgment or order as per the application, because when you look at the application, that sets out the relief that you're seeking, not the order that's sought to be made. If you approach the matter in that way, it's just lazy, and it points to a lack of understanding of what you are seeking by way of relief. Another way of looking at it, the reason for having your draft order or various versions of your draft order, whether you are for the applicant or the respondent, is that you can't start your case unless you know how you expect to conclude it. It's part of your job to obtain a form of order which generates a useful result for your client. Your function as an advocate hasn't finished when you stop speaking. You've got to get an order that works for your client. So you've got to think through the relief that you're seeking, and you need to consider what could go wrong with the order in the terms that you have initially drafted, and then recast that draft again. Let me say only a couple of words about other matters. Ex parte applications. Your paramount duty is to the court and to the administration of justice. As the High Court effectively noted in 2005 in Daughter Economiki, there is no conflict between the duty to the court on the one hand and the duty to the client on the other, because quite simply the practitioner's duty to the court always prevails. There is no conflict because the practitioner's duty to the administration of justice is always paramount. One of the essential integers of the duty to the court is the duty of candour, and nowhere is that more in focus than when you are appearing on an ex parte application. There's nothing new about this. In 1912, Justice Isaacs said that in order to fulfil this duty of candour, the lawyer for an ex parte applicant must supply the place of the absent party to the extent of bringing forward all material facts which that party would presumably have brought forward in defence to the application. Professor Del Pont summarised it thus: lawyers on an ex parte application must display the utmost fairness and good faith and see that all relevant matters for and against the application are brought to the court's attention. You will on occasion, turning to another topic, be opposed to litigants in person. They can be a challenge. Treat them with respect, afford them appropriate cooperation. The judge will be expecting you to remember that your paramount duty is to the administration of justice. And finally, just a couple of words about costs. Know what Rule 693 says. It says the costs of a proceeding do not include the costs of an application unless the court otherwise orders. So if you don't get a costs order, you won't get your costs as part of the proceeding. And also no Rule 698. If the court reserves costs of an application in a proceeding, the costs reserved follow the event unless the court otherwise orders. So if the default position that you adopt in your draft order is for costs to be reserved, then unless there's a subsequent order, those costs will follow the event. My time is up, ladies and gentlemen. The application's jurisdiction is one in which you will rise or fall on your reputation. If you have and value a reputation for accuracy, moderation and competence, then you will be respected by the judges. If you don't, then, as a past president of the Bar Association and in the presence of the current vice president of the Bar Association, the best advice I can give you is to go and brief counsel who does have that reputation. Thank you very much.
Thank you very much, Judge. Are there any questions for His Honour? Well, I do have one question, and it's for early career practitioners who may not yet have a practicing certificate. In the old days, clerks used to appear by leave. Is that still how a clerk should appear, particularly on a matter which is going to be adjourned and there are parties that reach that adjournment?
Once upon a time, as Stafford says, you used to have to get a thing called a chamber certificate as a clerk or an article clerk to appear in chambers. Yes, these days you need to seek leave to appear, is the short answer.
Well, thank you, Judge.